Hi, this is Dan Smith of DPS Legal Counsel, and welcome to today's episode of Business is More Exciting Than Any Game. Today I want to talk about trademarks, and in particular I want to talk about a case that's going to be coming up this year in the U.S. Supreme Court involving the well-known travel website Booking.com. Booking.com attempted to get a registered trademark for its name, Booking.com, but was turned down by the United States Patent and Trademark Office. It appealed that decision to the Trademark Trial and Appeal Board. It was again turned down by the Trademark Trial and Appeal Board. The reason that the USPTO and the Trademark Trial and Appeal Board turned down Booking.com's application for a registered trademark for its name, Booking.com, is because it was determined by the USPTO, the U.S. Patent and Trademark Office, that the name Booking.com was generic. And if you have a trademark application for a generic requested trademark, it will be turned down. The company, Booking.com, argued that the name was descriptive, and in particular the issue kind of became whether the addition of the .com to the name Booking may have changed what would be a generic name, Booking, which is generic to the service of doing hotel bookings. The name Booking just means bookings for hotels, and so that does appear to be generic in that sense. But the question was whether the addition of .com to Booking changed that genericness of Booking to something that is descriptive, and which someone who sees or goes to a site called Booking.com understands that the source of those services is that particular company, Booking.com. In other words, can you change what would otherwise be a generic trademark to a non-generic trademark, and thereby be allowed to get a registered trademark if you just add the additional language for your website, .com. So if you had, for example, a website, or if you had a company called, and I'm just throwing out an example, don't know if this is even a company or not, but if you had a company called Tables, and if you got a registered, if you got a domain for that on the internet for tables.com, could you get a registered trademark for tables.com where you might not be able to and shouldn't be able to get a trademark for tables because it's generic? So the question is whether you can just convert a generic trademark to a non-generic descriptive trademark by adding the .com to the name. The U.S. Supreme Court has agreed to hear that case, and that case will be heard this coming year. It's going to be very interesting. It's going to be important for companies to know whether they can get a trademark for something that would otherwise be a generic trademark by simply getting the top level domain for that name, that generic name, .com, and being able then to apply for the trademark as whatever it is, generic.com. So we'll see. We'll follow that, but it's important for businesses who are looking to brand to know what the parameters are for getting a trademark for their company. So I hope that helps. If you have any questions, please feel free to get in touch, and we'll talk to you next time. Thanks.